is our last official class, so I just posted, you should have gotten, if you haven't yet, practice exam and model answer key. The rule numbers are on there just so that you'll refer to them as you study. Between now and the close of business Wednesday, you can forward questions to me. I'm only going to do those questions that I receive for the review. Reviews work better that way if I can see what needs to be emphasized and clarified, and also helps you to sort of look through your notes and do it that way. And that the review doesn't preclude office hours or any other thing, but I think if you want to have a good and full effective review, just send me the questions, and that gives me a chance to work on them too, so that we can have an effective review. And then the exam is November the 8th. So between then and now, you will have questions or anything, certainly available to answer. So our last two classes have been sort of the soft classes. We've returned not to heavy problems like we did in the beginning, but our first couple of classes when we first started the semester were sort of soft classes too. And I just emphasize soft because we're not diving down deep into the rules, but that does not mean that the material's not important. This is important. So of course this isn't going to be a exam or essay question, but it's important for you to know what type of profession you're going into. I mean, so the profession has changed certainly since I practiced. Now, it wasn't prehistoric times, but things are certainly evolving. I think when you are in practice and in the middle of it, you'll see that things will be changing for you as well. So it's always good to sort of take a structural look at the practice of law. And things are changing with the major factors that we have up there. The recession really changed the alignment of big law. You know, you still have major law firms, the big multinational law firms, but some fell out of existence because of profits, too many partners, top-heavy, excessive salaries, all of those things. And so when 2008 came in, fundamentally reshaped what big law is. So you still have major firms, but less of them. And so these are some of the issues that we're going to look at, just sort of a broad global look at some things. And then lawyer advertising is going to be important as well. We're going to look at 7.1, 7.2, and 7.3. And it really flows from dealing with third parties. Because of the representations that we make in public, we have to be careful of what we say. And so this final chapter, starting on page 613, talks about the evolving business of law practice. Now, what do you know about unauthorized practice of law? UPL. So this happens all the time, and I say, no, I can't talk about that. I'm not really going to do that. So I'm admitted in Ohio and New York, but all the time I get calls, you tell me, well, I'm not admitted in Kentucky, so can I give advice on Kentucky law? That could be a problem. That's totally different than learning the line and teaching in a classroom. But this concept has a lot of really good things in it. We want to protect the public. We want to make sure that if these rules mean anything, we have the competence, expertise, technical skill, fully licensed, regulated. We want all of that to be to the benefit of the public. But one of the criticisms is that of our self-regulated profession is that we use this to create a monopoly. I mean, we don't want anyone else doing so. If you have law clerks doing something that we could do and charge for, that might be viewed as unauthorized practice. Non-lawyers providing aid. And so you see on page 614 this notion of licensing, education, and expertise protecting the public is the main thing. But this unauthorized practice concept varies from state to state. What is the practice of law? So there was criticism against this. You see on page 615, we have nearly every state having some type of statute barring non-lawyers from practicing law. But this concept has also come under criticism because we want people to have access to legal services, and they may not be able to afford some of the lawyers. And so why not open that up to non-lawyers who can perform routine matters? How do you feel about that? Non-lawyers performing sort of routine matters like filling out a form or something like that. What do you think? Yes, it's on.
I feel like we've kind of already had this discussion before when we were talking about, the development of legal websites like, LegalZoom.
Mm-hmm.
I don't know who exactly runs those websites, but on one hand, if they're the correct forms, like jurisdiction, then it seems pretty, I don't know, kind of almost like robotic. But on the other hand, it's, I don't know.
Yeah, why isn't that unauthorized practice of law? Something like LegalZoom. I guess it's how you define practice of law, right? And if you're just saying you're providing these forms, we advise you to consult with a lawyer, or this isn't legal advice, we're just providing you access to forms. Maybe that isn't advocacy and counseling and advising. But the book makes the point that unauthorized practice of law may be a real problem if you have something like immigration law, which is incredibly complex. And so you might have people being taken advantage of by posing as lawyers, the book says. And you see on page 617, this Quicken family lawyer, was that unauthorized practice? Texas legislature overturned that, and the U.S. Court of Appeals dissolved the injunction. So what about this? The book asks, is there some middle ground between permitting only lawyers to provide services and non-lawyers? Look at on page top of 620. You have Washington State, you have legal technician. So that's a person that goes through training, sort of like a paralegal, sort of like a gap between a non-lawyer, an experienced lawyer, and someone who can deal with specialized topics. What about that? Do you think that works? A trained non-lawyer to perform limited legal services. Does that help? Yeah.
That could work, as long as it is limited to just those areas, as long as they're not part of a more extremely complex.
Yeah. Well, how do you control and regulate that if you have just like legal technicians? Yeah, that's always going to be a problem. And I think we're going to see later on the advent of technology sort of makes it even more difficult when you can go online and get forms and then just use that to deal with legal problems. I mean, that was the whole point back on page 617 where you had Quicken family lawyers being first viewed as unauthorized, and then the Texas legislature overturning that in saying it really doesn't constitute unauthorized practice of law if you say that these products are just products, they don't substitute for the advice of a lawyer or a lawyer's expertise, and we're just providing you access. So there's always been this heavy discussion about what does unauthorized practice of law, what does it really do? It certainly is designed to protect the public and make sure that the public has access to lawyers who have the expertise, but it also can be used as a mechanism to keep our practice field closed, because we want to be the only ones with the expertise. That's the critique. So, lawyer advertising. This is something that proliferated. It never used to be like that. There's always a debate about whether or not law is a learned profession or is it a business. So that's why I had this question mark up here. And I think now everyone sort of says, yeah, it's a learned profession because of licensing, because of self-regulation, because of expertise. But whenever you have money in something, profit margins, you have a business. And so by the 70s, I say the late 70s, you have a fundamental change in how the law is viewed. It used to just be referrals. You look in something called the phone book and find an attorney. There's some advertising, maybe there's small print just saying specializing in, and then you'd go, or maybe somebody had worked with this lawyer before, you'd find out that way. But there's been a proliferation of advertising, and there are three major cases. Bates, that's 1977, and that just says most lawyer advertising is protected under the First Amendment. So, speech, you know from common law maybe, speech is sort of viewed as a hierarchy, and this isn't the top of the line speech like political speech. That's really a core constitutional value, helps us move forward our democracy, the marketplace of ideas, all of that. We really want to protect that. But you'll see the less speech is valued, the more the state can regulate it. And this is more like commercial speech, but most lawyer advertising is protected under the First Amendment, you see. And then we have another case called Oroliak, 1978. And it says the state could discipline lawyer who approached accident victims. So that's the unseemly part of law. That's the ambulance chase. So people in dire straits, we don't want their will to be overcome by a lawyer saying, just sign this retainer and we'll move on from there. You're entitled to a lot of money. So you see the basic protection under base, but then we also say that speech can be regulated when it impacts the public in a certain way. And then a case that came out of Kentucky, Shapiro. This case invalidated a Kentucky rule barring so you could see how this protection under the First Amendment is going to protect that type of speech, because everything comes through email, circulars, political advertisements like now, And so, you see on page 625, the scenario in Shapiro is a lot different than the coercive power of an attorney going to a hospital room or being on an accident scene and saying, I could be your lawyer. Here, if it's in the mail, people have time to reflect, people have time to read, and the court disagreed, explaining that a writing does not involve the coercive force of the personal presence of a trained lawyer. And there's no pressure on a potential client to make a yes or no answer. And so, notice this, and you'll see this on some advertisements that come through the mail. States can now require those letters to bear labeling, identifying it as an advertisement, or directing the recipient to report misleading information to the authority. So you'll see in small print, this is an advertisement. And so what's important about these cases is that they have tried to be codified in these rules, 7.1, 7.2, and 7.3. 7.1 just deals with communications concerning a lawyer's services. So someone tell me what 7.1 does. How can a lawyer advertise? This sort of flows from, this is another form of saying in the representations that we make to third parties, they have to be above board as well. So what about 7.1? How does it work? And then another question after we sort of look at these rules is, we have versioning technology, and then the question is, have these rules kept up with that technology, advertising on the internet and the like? So what does 7.1 say? How does it work, and how would you advertise as an attorney? It seems like it's a really short and quick rule. What about it? How does it work? Can I say something like this? I'm just out of law school. I've been practicing 2 years. I've had 3 cases. I've won them all. And I advertise 100% win percentage guaranteed, listed as one of the great attorneys of the past 5 years, rated nationally, can try any case. And I'm about to be admitted in the National Academy of Trial Lawyers. I put in the application, so I'm about to be admitted. I win every case, and I guarantee that I win. It's more. What's wrong with that? Yeah. Yeah. And get in trouble. So can't guarantee results. Do the advertisements on TV guarantee results? Do you think they're guaranteed results? Like the Hammer or Marshall Hills and the Tiger? What about that? See, there's even a crazy ad. Have you ever seen this ad? It was horrible. I'm glad they took it off from TV. It said, Mama, I'm in jail. Call Mr. Waddell. The attorney. You ever seen that? Yes, it played like 3 or 4 times. It was horrible. And then you're laughing because that puts us sort of in a bad light. And so this was, in the 70s, this was a raging debate whether or not we should even allow advertising, because it sort of the argument goes, it sort of sullies the profession because we're supposed to be a learner profession, not a business. That line is clearly blurred. You can tell even from the chapter title that now everyone recognizes that at least underlying this learner profession is a business. Mr. Mallon, you had your hand up?
I was gonna say it seems borderline on those commercials. 'Cause
Yeah.
they're saying like, we'll get you your money and.
Yeah. But then you see the little small print, results may vary, just because this attorney like Morgan and Morgan said, you think that Mr. Morgan is actually gonna take your case, and then in the small print it says, no, this may be handled by other attorneys associated with the office. Then it has, limited bar and all of that, so all of those things. Ms. Harper?
Yeah, kind of hanging off what he said with the TV commercials. I feel like they kind of like, at least with those, they can tend to back up sort of what they're saying with not only, of course, small print kind of like qualifying what they're capable of doing, but
Right.
they do have like, like actual case testimonials. And you see this on attorney websites too, where you have like clients, former clients, like saying, what these attorneys are able to do for them. So that's almost like, it's almost like evidence that backs up your claim. But if you just go out the gate and say like, I guarantee to win a case, like I've never failed a case before, it's like, okay, well, you haven't had that many cases, so where are your testimonies, where's your proof?
Yeah, so tell me a little bit more about testimonials. How far can you go with those based upon the rule? 'Cause that's interesting.
Well, obviously testimonials, you can't like reveal any sort of confidential information from that client or former client. That's a violation of 1.6.
Oh yeah, no confidential information, that's true.
But I think based on what I've seen, what you can reveal is like, maybe sort of like just general, because like something that might be kind of like a commonality between the sorts of cases that the lawyer specializes in. Like for example, with Daryl Isaacs, who specializes in personal injury, especially with like, dealing with accidents involving like semi-trucks. That's kind of the commonality of the testimonials that I've seen from him is these clients are talking about, medical damages that they received from their accidents, and so those sorts of like, something that's kind of like a common thread between the cases that he specializes in.
That's good. So something that emphasizes commonality and expertise in practice, we certainly can highlight that. But 7.1 says that statements must be truthful. And notice comment 2, this is what we were just talking about. Truthful statements can be misleading. So my little hypo, if I say I won 100% of my cases, that's true, but I've only had 3 cases, and that sort of implies that I have a lot more experience than I have. So if you look at comment 2, it says truthful statements that are misleading are also prohibited by this rule. A truthful statement is misleading if it omits a fact necessary to make the lawyer's communication considered as a whole not materially misleading. So I left out the part that I only had 3 cases in 5 years. I left out the part that I'm applying to be in the National Academy of Trial Lawyers, haven't been approved yet. And so a truthful statement is also misleading if it's a substantial likelihood that it's going to lead a reasonable person to formulate a specific conclusion. So I wanted that person to conclude that I'm a great trial lawyer based upon limited experience that I don't fully represent. So truthful statements can be misleading. And then comment 3, I'll just put no unjustified expectation. So you can't say something like, I win every time. So, back to the TV ad, you have to make sure that those aren't unjustified expectations. In those particular cases, yes, this amount was won, but you see small type results may vary depending on the factual circumstances and the law. This attorney may not be the one representing you, could be handled by someone else in the firm. This attorney is only admitted in Ohio and Indiana, not Kentucky. So, an advertisement that truthfully reports a lawyer's achievements on behalf of clients or former clients may be misleading and presented so as to lead a reasonable person to form an unjustified expectation that the same results will be achieved in every case. So, and it also points out what I just said. The inclusion of an appropriate disclaimer or qualifying language may preclude a finding that the statement is likely to create unjustified expectations or otherwise mislead the public. So if you talk about all of those things that you've done, you also have to contextualize those things and make sure that you're not giving the impression that all results are the same. Everybody can't get $100,000 on this particular case. The facts may be the same, but different juries, different judges, different contexts. Yes?
So this is now what gets me confused then, when it comes to like where attorneys are licensed to practice, because I've noticed this with like one big firm that I've seen like advertise on TV, they're licensed only in Indiana. So why are they advertising in Kentucky?
Oh, because they're probably affiliated with some Kentucky lawyers. And the thing that they have to watch out for is not practicing on those cases if they're not admitted. But if you're affiliated, usually those are affiliated offices. So I could even be a practicing attorney in Kentucky, not working here, but make it clear that, like if I'm at Frost Brown Todd, on my letter here it would just say admitted only in Indiana. And that's a clear sign that I'm not working on any Kentucky matters because I'm not licensed here, but I may go across the bridge and work in Indiana, and that's fine. So those are usually scenarios where the lawyer is affiliated with someone locally and they still represent clients, but not on Kentucky matters.
Okay.
Yeah. So for example, there's something called Pro Hac Vice. So let's say if that Indiana lawyer who works for Frost Brown Todd in Kentucky is working on something and maybe they're shorthanded, only admitted in Indiana, but we need to file some pleadings very quickly in the Kentucky State Court. We could go, we would have maybe an affiliated lawyer from Kentucky move for admission of the Indiana lawyer for that particular litigation, Pro Hac Vice. So it really deals with just litigation, not transactional matters, but you could be admitted for that one point in time on that particular litigation if you're not licensed. And you do that by motion to the court. There's a footnote in our readings about that. Oh, on page 627. Footnote 59. So that's 7.1. 7.2 talks about advertising. So this is governed by 7.1. You have to be truthful. And 7.3, you can't solicit in person. Subject to those, you can advertise written, recorded, or electronic communication, including public media. So does this tell us how we can use public media, social platforms? you see on page 626, it says, it asks this question. How do you answer? May lawyers solicit clients over the internet? Now, you have to be careful with this because look at 7.2b. A lawyer shall not give anything of value to a person for recommending a lawyer's services. And there's some reasonable things that a lawyer can pay for. It can pay for the cost of advertisements, the usual charges of legal services, plan or not-for-profit or qualified lawyer referral service. So that lawyer referral service would be something that's approved by an appropriate authority. So maybe the LBA has another office that talks about commercial transactions and you pay dues as part of LBA. That's not paying for a referral. Paying for law practice, of course, and referring clients to another lawyer pursuant to an agreement. But the primary prohibition is that lawyers should not give anything of value to a person for recommending the lawyer's service. I'll just put, can I give value for? So what about the internet? You see the little example in there? So what about this free t-shirt example? How do we explain that? The whole point of this section is that the internet has sort of opened up new ways of advertising and getting clients. So you have this sort of free t-shirt giveaway and the chance to win a prize if you sort of take a picture of yourself on Facebook or Twitter and so this Groupon example, fixed amount of money for each new client attracted by the third party's website. One law firm gave out free t-shirts with his name on them and offered a chance to win a prize to all who posted Facebook photos of themselves wearing the t-shirt. Is that giving something of value for a referral to a law firm? Is it? The book says no, but I want to know why is that? Ms. Harper?
I say, for me at least, I say it depends on what the prize is.
Yeah.
Because if the prize is like, a certain amount in cash, like a monetary prize, then yeah, that's giving something of value. But if it's like, some sort of like something that's kind of, I don't know, like a trinket or something, then it's not really something of value per se.
What is about one thing that we have to look at is 7.2. We have to look at a number of comments. Comment 1, comment 2, and particularly comment 5 when we talk about this. So comment 1 just says, we want to assist the public in finding legal services. And so we want to allow advertising to let the public know about the service that we have. Not only through reputation like it was in the old days, but through organized information campaigns in the form of advertising. So while we're trying to look for clients, and it's sort of contrary to this old professional notion that we shouldn't go out and hunt for clients, they should come to us for our expertise. This rule says However, the public's need to know about legal services can be filled in part through advertising. So we're trying to regulate advertising, keep it respectable, but provide for access. And it talks about the need being particularly acute for underserved communities. So that's what we're trying to do. So recognizing all of that, if we're trying to assist the public in finding and securing legal services, a risk in allowing advertising is that this advertising could be misleading. So we're concerned about that. Comment 2 talks about how we disseminate information. The kinds of services a lawyer will undertake, the basis on which the lawyer's fees are determined, including prices for specific services. So this rule talks about public dissemination of information. But back to whether or not we are giving something of value. Comment 5 talks about that. What does comment 5 tell us in terms of finding an answer to whether or not it's permissible to have this t-shirt contest on the internet, advertising a law firm? Now, you still see in the rule that it really doesn't address whether or not internet-based lotteries are permitted. And the book even says as technological advances are made, these rules are going to have to keep up. And the ABA is really slow. The ABA looked at this a little bit and said, well, maybe we're just going to keep things the same. You see at the top of page 627. So what about this hypo? I want to sort of resolve it. One lawyer gave out free t-shirts with his name on them, offered a chance to win a prize to all who posted Facebook photos of themselves wearing a t-shirt. And the question is that giving something of value for a referral? There's some discussion. Comment 5 is really long, but it talks about lead generators. That's some entity like Groupon that's pushing out this promotional material that solicits, and it makes distinctions there. So you think this is permissible? Why? Notice this is the little sentence I'm referring to. I want you to tell me why it's permissible. In 2012, the ABA amended comment 5 to model 7.2 to clarify that paid per lead services and promotions such as the t-shirt lottery are permissible. So what makes this t-shirt lottery permissible? What can you point to in the comment that says this is okay? Yes, go ahead. Thank you.
Excuse me. For me, it's that like wearing the T-shirt isn't recommending; it's simply getting the name out.
Mm-hmm.
It's not like you're having people say,
Mm-hmm.
you know, like
Groupon isn't saying you go here and you get the T-shirt and we'll recommend it.
Right.
Yeah, that's good. And so that was kind of a murky area, but that just shows that's very good. Comment 5 points to that. So pay per lead services and promotions are permissible, but notice it's a long rule, I know, but it's sort of buried here. You cannot pay a lead generator like Groupon to recommend lawyer services. So the only thing they're doing, as Ms. Boyd points out, is just pushing out the name. And they're not getting paid for that. And so a lawyer may pay others for generating client leads, such as internet-based client leads, as long as the lead generator does not recommend the lawyer any payment to the lead generator is consistent with Rule 1.5, division of fees between lawyer and non-lawyer, and the professional independence of the lawyer is not compromised. And the lead generator's communications are consistent with 7.1, can't be misleading. So this is permissible. This is just a name on the t-shirt, offering a chance to win, getting the name out. Now, another thing you see on the top of page 627, what about solicitation by text message? You know, you get all kinds of junk on your phone now, and I guess law firms can be involved in that too, pushing their name out. But do you think it's pretty interesting what Ohio's doing? Ohio's fairly rigorous. So you can solicit through text messages. This is just an example. Solicit through text messages, so long as you're not soliciting a minor or a claim isn't pending. And you can solicit through text messages, but notice the lawyer must assume the cost to the prospective client of receiving the message. So I don't know how that would work. So a lawyer will send a text message to prospective clients, and I guess on some level the book says you're supposed to ask the client, are you going to get charged for the prospective client? Are you going to get charged by this because your service is Verizon compared to AT&T? If you can't accept it, then it seems like the lawyer would have to pay, the book suggests. Reimburse each one who responds in affirmative. But the bottom line is the lawyer should be very careful about offering anything of value in order to secure referrals that lead to service. On page 628, comparisons are made between international practice in the EU compared to our practice. We are still a state-based regulatory framework, so it's not as easy for us to do multi-state practice and move from area to area. And the EU is free flow and very flexible. If you are an attorney admitted to practice, you see on the top of page 628, far fewer geographic restrictions on law practice. Excuse me. Now we have some flexibility in terms of reciprocity, but you have to find the right states who are participating so that you can have reciprocity. And that is limited compared to what we have in Europe. Burbauer, this case on page 628, was really a graphic display of how restrictive the practice laws are. So you have the flexibility that you have in Europe, but notice how inflexible it is in this Burbauer case. You have some New York lawyers helping a California company. The lawyers go to California, they meet with clients, they meet with accountants, they help resolve and settle a dispute. They also meet with other representatives on the company, they discuss settlement between both parties. Arbitration was contemplated, but the case ultimately settled. And the New York lawyers say, well, we want to be paid. They sue their client for the fee, and the client defends by claiming, well, this was the unauthorized practice of law. The New York lawyers were not admitted in California, so that was the unauthorized practice of law. And the California Supreme Court held that the fee agreement was unenforceable because the New York lawyers were not admitted to practice in California. So that was a very rigid holding. And so this case also went on to say that a out-of-state lawyer can commit unauthorized practice of law without even setting foot in the state by advising on California law outside of the state. And so, and this goes even further, even if you're affiliated, so this is even worse, because even affiliation with a local California law firm is not enough. So this decision was ultimately overturned in part by a California state statute. And most states sort of have a little bit more flexibility than this, and they look at Model Rule 5.5, which tries to loosen this standard and allow lawyers to associate with other lawyers so that they won't be susceptible to unauthorized practice claims. So you see on page 629, these things, you have to be affiliated with another lawyer. Then it talks about the different subject matters that have to be being litigated. That has been codified in 5.5. So if you look at 5.5C, it sort of takes up what's in the book. I'll just put unauthorized practice as well. So this says, if you're admitted in some U.S. jurisdiction, you haven't been disbarred or suspended, you're in good standing, you can provide services on a temporary basis. So you need to be affiliated with someone who is admitted to practice in a jurisdiction, actively participates in the matter. And then it goes on with the same type of requirements here. Preparing or pending litigation. Lawyer's work arises out of the practice in the jurisdiction in which the lawyer is licensed. So the vast majorities of jurisdictions have adopted something like 5.5 to move away from this restrictive, no, you cannot practice if you are not admitted here, stance that the court took in Burbine, the California court. Multidiscipline practice. This again goes back to the notion of monopoly. State bars have been very reluctant to expand what the scope of practice is. So the notion that we have a lot of complex problems now, and we may need to collaborate with other professionals has not really caught on. If the lawyer cannot totally control through a law firm how matters will be handled, there's been a general reluctance to expand that view of what practice is. So you see on page 631, this notion that lawyers and other professionals are partners has generally been prohibited. And so we're still going to have to keep grappling with this question about what about the scope of modern problems, and what does that mean for how we practice? And the common claim is that what we're trying to do is preserve the lawyer's independence. But it seems to me that there should be a way to balance that with looking at problems in new and different ways, because problems, technology, the practice of law is all changing, and perhaps the same rigid model of the lawyer controlling everything may not be the best solution. May have to be more creative in terms of how we deal with modern day problems. Changes in private law practice. So I sort of touched on that. That's on page 634. The recession of 2008 really changed private practice. A lot of major firms went out of existence. And there's been a shift to sort of specialization in specific areas. So if you can pay a lawyer who has the expertise and is licensed to deal with discrete problems like reading contracts and offering recommendations on them, or drafting research for discrete problems, you save money. And so there's been, coming out of the recession of 2008, and even before that the law was changing, but I think the recession of 2008 exacerbated things. You have contract lawyers working on specific items. You have outsourcing, so it's a lot cheaper maybe overseas like India to have someone working on a matter and saving money that way. Onshoring, maybe using smaller offices with an assemblage of contract lawyers dealing with problems. And the internet changes everything because how we advertise and attract customers is changing as well. And then there's globalization, another form of broad-ranging practice. So the way things are, you're not only going to have to know, if you work at an international firm, all of our domestic problems, but how our domestic laws, rules, and regulations mesh with where we are practicing. And so if you're practicing in an area, you're not going to be limited just to the model rules in Kentucky. You're going to have to understand what the rules are in Europe as well. And also, just because a lawyer is a temporary lawyer does not mean that they are not impacted by the rules. They have to abide by rules like 1.6, 1.7, all of those things. So just because it's for a temporary discrete matter, the rules still cover all of this, all of their activities. And then finally, the book talks about new methods of financing legal work, a number of different ways. There's even talk about investment in law firms. That hasn't totally gotten off the ground, but there certainly is talk. And so the title, Evolving Business of Law Practice, is totally appropriate because now we're talking about the law as a business. Certainly with the underlying intention of the law as a learned profession, but we've certainly made a shift to looking at profit and how that impacts the practice of law. So that's it, I've run out of material. So make sure you sort of give me questions, that's fine, and we'll meet here again, regular time. As if it's a class, and we'll do a review. So I'm accepting questions until tomorrow at 5 o'clock. And then I'll just answer those questions. Then office hours, regular, up until the exam. Have a good afternoon.